Your Honor, the next matter for the court is the State versus Hugh Franklin Johnson II, 18 CRS 265, 268, 293, 295, 268, 267, 265, and 266, Judge. Mr. Johnson is present in court with his attorney, Mr. George Kelly. Mr. Kelly, in file number 18 CRS 293, how does your client plead to one count of obtaining Class C obtaining property by false pretenses?
Pleads guilty.
In file number 18 CRS 294, how does your client plead to one count of Class C obtaining property by false pretenses?
Pleads guilty.
In 18 CRS 268, how does your client plead to one count of Class C obtaining property by false pretenses?
Guilty.
In 18 CRS 267, how does your client plead to one count of Class C obtaining property by false pretenses?
Guilty.
In 18 CRS 266, how does your client plead to one count of Class C obtaining property by false pretenses?
Guilty.
And in 18 CRS 265, how does your client plead to one count of Class C obtaining property by false pretenses?
Guilty.
And in file number 18 CRS 293, how does your client plead to one count of Class H obtaining property by false pretense?
Guilty.
And in 18 CRS 294, how does your client plead to one count of Class H obtaining property by false pretense?
Guilty.
Your Honor, if I may approach.
Yes, you may. Yes, you may. Go ahead and be seated. Go ahead and be seated.
Your Honor, the state will need to sign the transcript.
All right. I'd like to go ahead and do that. You may approach.
That's fine. And Your Honor, just a point of clarification, this was modeled off of a previous plea agreement. We had not filed the notice of aggravating factors at that time. We can update the language of the agreement to show that we're not pursuing those in writing if the court prefers.
I'll just make a verbal inquiry.
Thank you.
There's just one aggravating factor for each. Is that correct?
That's correct.
Right. Well on.
You say for two.
First Benjamin, I want him to sign it now, Judge.
Yes, please.
There were two, we gave notice of two aggravating factors, position of trust and excessive amount.
And that what was the other? He occupied a position of, what was the second aggravating factor?
One was position of trust and the
Okay.
other was the amount of the embezzlement or obtaining property.
Folks, the bench, Your Honor.
Yes, you may.
Did you sign?
Madam Clerk, if you please swear the defendant.
You would place your left hand on the Bible and raise your right. Do solemnly swear that your answers shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Remain standing. Put your hand down.
Okay.
Mr. Johnson, you able to hear and understand me?
I am, yes.
Do you understand that you have the right to remain silent and any statement you make may be used against you?
Yes.
And what's the highest level of education you've completed, sir?
A master's degree?
Are you now using or consuming alcohol, drugs, narcotics, medicines, pills, or any other substance?
No.
And when was the last time you used or consumed such a substance?
Over a year ago?
And do you believe your mind is clear and do you understand what you're doing at this hearing?
I do, yes.
And have the charges been explained to you by your attorney? Do you understand the nature of the charges and every element of each charge?
Yes.
And have you and your attorney discussed possible defenses, if any, to the charges?
Yes.
And are you satisfied with your attorney's legal services?
I am, yes.
Do you understand that you have a right to plead not guilty and have your case tried before a jury?
Yes.
And do you understand that at such trial you'd have the right to confront and cross-examine the witnesses against you?
Yes.
Do you also understand that at a jury trial, do you understand that by your plea you give up these and other valuable constitutional rights to a jury trial?
I do, yes.
Do you understand if you're not a citizen of the United States, your plea of guilty or no contest may result in your deportation from this country, your exclusion from admission to this country, or the denial of your naturalization under federal law?
Yes.
Do you understand that upon conviction of or following a plea of guilty or no contest, there are limitations on your right to appeal?
Yes.
And do you understand that a plea of guilty may impact how long biological evidence related to your case will be preserved?
Yes.
And do you understand that you're pleading guilty to 6 counts of obtaining property by false pretenses in an amount in excess of $100,000 and 2 counts of obtaining property by false pretenses in an amount less than $100,000?
Yes.
Do you now personally plead guilty to the charges I just described?
I do, yes.
And are you in fact guilty?
Yes.
Do you understand that those charges carry a maximum punishment of 1,401 months?
I do, yes.
Do you understand that you have a right during a sentencing hearing to prove to the court the existence of any mitigating factors that may apply to your case?
Yes.
And do you understand that courts have approved the practice of plea agreements and you can discuss your agreement with me without fearing my disapproval?
Yes.
And in case I didn't ask it, you do admit that you are in fact guilty to the charges I just described?
Yes.
And you're pleading pursuant to a plea agreement, is that correct?
Correct, yes.
And it's my understanding the terms of the plea are that in exchange for your plea, in file 18 CRS 265, you will be sentenced to an active sentence in the presumptive range to a minimum of 70 and a maximum of 96 months. The judgment in 18 CRS 266 shall be consolidated into the judgment in 18 CRS 265. In file 18 CRS 267, you will be sentenced to an active sentence in the presumptive range to a minimum of 70 months and a maximum of 96 months. The judgments in 18 CRS 268, 293, and 294 shall be consolidated into the judgment in 18 CRS 267, and the sentences in 18 CRS 265 and 267 shall run consecutively. That means you're going to have 2 sentences of 70 months to a maximum of 96 months, which will run consecutive. Do you understand that?
I do, yes.
The state agrees to dismiss 6 Class C felony counts of embezzlement and 1 count in each of the following cases: 18 CRS 265, 266, 267, 268, 293, 294. The state also will not proceed on the 2 aggravating factors that they have given notice of, that being you occupied a position of trust and the amount at issue was of great monetary value. And you will be ordered to pay restitution in the amount of $5,867,408. And the state agrees to, as I indicated, to dismiss the 6 counts of embezzlement. Is the plea agreement that's set forth on the transcript, and as I've just described it to you, correct as being your full plea agreement?
Yes.
Do you now personally accept this agreement?
I do, yes.
Other than the agreement between you and the prosecutor, has anyone promised you anything or threatened you in any way to cause you to enter this plea against your wishes?
No.
Do you enter the plea of your own free will, and do you fully understand what you're doing?
I do, yes.
And do you agree that there are facts to support your plea, and do you consent to the court hearing a summary of the evidence?
Yes.
Do you have any questions about what has just been said to you or anything else connected with your case?
I do not.
All right, sir, you may be seated, and I'll hear from the state.
Your Honor, $5,867,408.64. That is the amount of money that this defendant stole from the company BMG LabTech Inc. through the years of 2012 and through 2017. Your Honor, BMG is a German company that its U.S. headquarters is located out of Cary, North Carolina. The president of that company is an individual by the name of Ronald Earp, who is in the courtroom here today. Judge, the evidence would have shown that in 2001, this defendant was hired by BMG to be an assistant to the bookkeeper at that time. And shortly thereafter, after that bookkeeper left, Mr. Earp promoted this defendant into a position of office manager. And at that point, he became the corporate secretary for the company. In that role, his job was to manage all things finance for the United States branch of BMG LabTech Inc. He was to do the invoices, to manage the online banking, to handle payroll, to handle insurance. That role did not authorize him to unilaterally make financial decisions, but he was the one with primary access to the bank account and the credit card for BMG. Judge, Mr. Earp would have further said that in this role, this defendant was trusted to execute those duties by not only himself, but by various employees of this company, that he was issued a credit card and would turn in expense reports that appeared to show that this defendant was using BMG expenses or money for BMG expenses. In August of 2017, BMG unfortunately realized that the trust that they had put into this individual as corporate secretary, a corporate officer for this company, was misplaced. During this time, the BMG had hired an outside CPA to do primarily sales tax for the corporation in the United States. That individual, Ed Palumbo, also took bank statements provided by the defendant and compared them to QuickBooks entries also made by the defendant. And it was in August of 2017 that Mr. Palumbo realized that something wasn't adding up. And he was able to unearth that the bank statements that were being provided to him by the defendant were altered and that the QuickBook entries were false. Mr. Earp and Mr. Palumbo worked together to get the legitimate bank statements from First Citizens Bank, the only banking establishment that the company used, and the credit card statements for Mr. Johnson for the BMG issued credit card to that First Citizens Bank account. Very quickly, they realized that a vast amount of money was going unaccounted for because the person that they trusted, this defendant, to manage that money was making personal wire transfers, personal credit card charges, personal travel expenses, and writing personal checks. At that point, BMG hired Protus 3, a private security company, to help them with this investigation because it became quickly apparent that this was more than they could manage, just the two of them. Tasha Dyson with Protus 3 led that investigation, and her and Mr. Earp went charge by charge, wire transfer by wire transfer, travel expense by travel expense, check by check through BMG's bank statements and credit card statements. At the point at which they discovered about $250,000 of unauthorized financial transactions by this defendant, it was the decision of Protus 3 to contact Cary Police Department, and an individual by Protus 3 and a detective from Cary Police Department sat Mr. Johnson, the defendant in this case, down for an interview on October 2nd of 2017 to confront him with this $250,000 that they had discovered thus far. And what they got during that interview was a confession to the $250,000 that they had discovered at that point. This defendant admitted to using BMG money for traveling with his friends, lavish dinner parties at Ruth's Chris, wine clubs, home food delivery services, expenses that had nothing to do with BMG or the financial well-being of BMG. Judge, during this interview, the defendant describes how some of his wire transfers to his various bank accounts, which the evidence would have shown that at the time this was going on, this defendant had 6 bank accounts with 6 different banking establishments, was matching the amount that he was transferring to some of those bank accounts, the amount to legitimate bank expenses, so that way it might go unnoticed by the company. Judge, at the end of that interview, Detective Orr with Cary Police Department stated to the defendant, asked the defendant, how far back do you think that they looked to find $250,000 of theft? And this defendant said he didn't know. And Detective Orr said it was only 2 years. And they had previously had a discussion about how this defendant had been doing this since 2009. And at that point, Detective Orr said, what do you think they're gonna find when they keep looking? And this defendant said, a lot. And they certainly did find a lot, Judge. They found $5.8 million. Over the next several months, Mr. Earp and Tasha Dyson with Protus 3 would continue going back. Eventually they stopped at 2012 just due to the volume that was already found. And again, go line by line to figure out whether or not charges were authorized or unauthorized, Judge. They found personal spending on everything from gas to pornography to $25,000 dinner parties or birthday parties for the defendant at Ruth's Chris, to trips to Cancun for the defendant and 10 of his best friends, to Ritz-Carltons, to wedding gifts in the amount of $5,000. Judge, the amount of spending that it takes for an individual to completely spend nearly $6 million in 6 years, it's alarming, and it was a lot of documents. Judge, on February 6th of 2018, the indictments in this case came down. On that same day, the defendant sent an email to 2 of his best friends indicating that he was going somewhere he would not be found and giving those individuals some login information to his personal computer and safe in his home. Those individuals arrived at the house unable to find the defendant, and at that point, law enforcement started looking for the defendant. The defendant was found in Halifax County driving towards I-95 with little but a gun in the back of his car. Judge, at that point, as the State Bureau of Investigation got involved and again went line by line, charge by charge to make sure that the calculation in this case would be the most conservative calculation that it could be, and even at that, we are at a loss of $5,867,408.64. Your Honor, that would have been a brief factual showing for the state had this matter gone to trial.
All right, this defendant wish to have any facts or want to add to that factual basis?
Mayor?
No.
Do you stipulate that it forms factual basis for the offenses charged?
Yes, Your Honor.
All right. Before we proceed with sentences, we're going to take about a 5-minute recess. I want to talk to the counsel in chambers for a minute.
Superior Court stands in recess for 5 minutes.
Your Honor, there's been a motion by the state to amend the indictments in 5 of the 6 files to bring the amount in the obtaining property by false pretenses to include the amount reflected in the embezzlement, to bring the total of the obtaining property by false pretenses amounts to the total amount lost by BMG. In file number 18 CRS 268, in count 2, the state has moved to amend the amount which was listed as $279,146.75 to the amount of $1,209,119.42. And I believe that the defense consents to that amendment.
Correct, Your
All
Honor.
right.
And Judge, the time frame for that case number is between January 1st, 2015 and December 31st of 2015. In 18 CRS 267, Judge, in count 2, this being the time frame from January 1st, 2014 to December 31st of 2014, the state moves to amend the amount listed in count 2, which was originally $348,078.10 to the amount of $1,070,942.68. I believe the defense consents to that amendment.
Correct, Your Honor.
Your Honor, in 18 CRS 293, this charging instrument covers the time frame from January 1st, 2016 until December 31st of 2016. In count 2, the state moves to amend the amount in that count, which was originally $299,232 even, to the amount of $1,681,044.22. I believe the defense consents to that amendment.
That's correct, Your Honor.
In file number 18 CRS 294, Judge, this is the time frame, this charging instrument covers the time frame from January 1st, 2017 till October 2nd of 2017. The state moves to amend. It's all amended. No. Your Honor, that charge, yeah, it is. The state moves to amend count 2 in that the amount in count 2, which was originally $169,458.60 to the amount of $1,333,973.28. I believe the defense consents to that motion.
Correct, Your Honor.
Your Honor, in the charging instrument 18 CRS 266, this is the charging instrument that covers the time period from January 1st of 2013 through December 31st of 2013. In count 2, the state moves to amend the amount of loss from the written amount of $263,481.50 to the amount of $295,835.11. I believe the defense consents to that amendment.
That is correct, Your Honor.
And Judge, in the file number 18 CRS 265, this is the charging instrument that covers the amount of time from December 5th, 2011 through December 31st of 2012. The amount in count 2, the obtaining property, did not need to be amended. That amount was correct.
All right. As the amendments are not substantive amendments, as they don't change the felony class level, just the dollar amount for the Class C, and with the consent of the defense, the court will grant the motion to amend the indictments. Does the defense stipulate to that the amounts now in the amended indictments were obtained by false pretenses during the dates and times alleged and through the manner previously discussed?
Yes, Your Honor.
All right. And the defense does not wish to be heard on the factual basis, correct?
That's correct, Your
All
Honor.
right, I'll hear from the state on sentencing.
Your Honor, the state would like to hand up State's Exhibit Number 1.
Mr. Kelly. record.
You know, I believe actually the state needs a few minutes. If
All
we
right.
could take a brief recess,
I will
Your
take 5
Honor, I
minutes.
apologize.
That's fine. We'll take
Thank
5
you.
minutes, 10 minutes.
We probably need to go back in chambers again.
All right.
Superior Court stands in recess for 10 minutes.
Your Honor, in each of the file numbers that have been previously discussed, the state has done superseding informations to correct the means by which this defendant obtained property by false pretenses to match the amounts as previously discussed on the record. The defendant has consented to those superseding information and waived any defect in process, if I may approach.
Is that correct, Mr. Kelly?
That's correct, Your Honor.
And all right, so out of an abundance of caution, I'm going to redo at least my plea inquiry of him. I don't know that we need to do the factual basis, but I do want to make sure that he's agreeing to plead guilty to the informations. And,
You understand what we're going to do it again? Okay.
all right, Mr. Johnson, if you please stand, I'm going to remind you that you are still under oath. Are you able to hear and understand me?
I am, yes.
Do you understand that you have the right to remain silent and any statement you make may be used against you?
I do, yes.
What's the highest level of education you've completed, sir?
Master's degree?
And are you now using or consuming alcohol, drugs, narcotics, medicines, pills, or any other substance?
No.
And when was the last time you used such a substance?
A year ago?
And do you believe your mind is clear and you understand what you're doing at this hearing?
Yes.
And have the charges been explained to you by your attorney? Do you understand the nature of the charges and every element of each charge?
Yes.
And have you and your attorney discussed possible defenses, if any, to the charges?
Yes.
And are you satisfied with your attorney's legal services?
Yes.
Do you understand you have a right to plead not guilty and have your case tried by a jury?
Yes.
And do you understand that at a jury trial you'd have the right to have you'd have the right to confront and cross-examine the witnesses against you?
Yes.
And do you understand that by your plea you give up these and other valuable constitutional rights to a jury trial?
Yes.
And do you understand if you're not a citizen of the United States, your plea of guilty may result in your deportation from this country, your exclusion from admission to this country, or the denial of your naturalization under federal law?
Yes.
And do you understand that following a plea of guilty or no contest, there are limitations on your right to appeal?
Yes.
And do you understand that your plea of guilty may impact how long biological evidence related to your case will be preserved?
Yes.
And do you understand that you're pleading guilty to 6 counts of obtaining property by false pretenses in an amount in excess of $100,000 and 2 counts of obtaining property by false pretenses in an amount less than $100,000? And do you understand the total maximum punishment for those offenses is 1,401 months?
Yes.
And do you now personally plead guilty to the charges I just described?
Yes.
And are you in fact guilty?
Yes.
Do you understand you have a right to, during a sentencing hearing, to prove to the court the existence of any mitigating factors that may apply to your
Yes.
case? And do you understand that courts have approved the practice of plea agreements and you can discuss your plea agreement with me?
Yes.
And you're pleading as part of a plea agreement, is that correct?
Correct. Yes.
And it's my understanding that count 18 CRS 266 will be consolidated into 18 CRS 265, and you'll be sentenced to a minimum of 70 to a maximum of 96 months. The counts in 18 CRS 268, 293, and 294 will be consolidated into 18 CRS 267, and you'll be sentenced to given a sentence of a minimum of 70 months to a maximum of 96 months. That sentence will run concurrent with the sentence imposed, consecutive with the sentence imposed in 18 CRS 265, and that you will pay restitution in the amount of $5,867,408. The state agrees to dismiss the 6 counts of embezzlement in an amount in excess of $100,000 and not proceed on the 2 aggravating factors, that being that you occupied a position of trust and that the amount involved was of great monetary value. Is the plea agreement that's set forth in the transcript and as I've just described it to you correct as being your full plea agreement?
Yes,
Do you now personally accept this agreement?
I do, yes.
And other than the plea agreement between you and the prosecutor, has anyone promised you anything or threatened you in any way to cause you to enter the plea against your wishes?
No,
And you enter this plea of your own free will and you fully understand what you're doing?
I do, yes.
And do you agree that the previous factual recitation made by the state is sufficient to support your plea? And do you consent that I can consider that summary of the evidence that they presented?
Yes,
And do you have any questions about what has just been said to you or about anything else connected with your case?
I do not know.
Do you want to add anything else to the factual basis?
Judge, I would just ask that Your Honor consider the dates and the amounts as we've discussed them this morning on the record, as well as State's Exhibit 1, which was handed up by Ms. Freeman earlier, that outlines the values of loss as well as the dates for each year.
And that the manner of transfer for the obtaining property false pretense was by either ACH, wire transfer, check, credit card, UATP, or insurance?
Judge, yes, the way that the information reads is that it was by means of altering bank statements and falsely populating QuickBook records of the victim corporation, which encapsulates all of those that Your Honor just mentioned.
And defense stipulates to that?
Yes, Your Honor.
All right. You may be seated, sir. I will hear from the state on sentencing.
Your Honor, briefly, I appreciate your forbearance this morning as we've worked our way through this plea. This is quite possibly the largest embezzlement case in Wake County history. And throughout this process, we have gotten to know the president and members of B&G Corporation. As I said to President Earp this morning, this is a company that is an outpost of a German company. It is a staff or a team of less than 20 that travels nationally and sells very high-end scientific equipment for various lab testing. And all of them reiterated to us how much they have been taught and appreciate the fact of trying to be good corporate stewards for their company and keeping their expenses down. This was something that took them by surprise. They all felt a sense of betrayal by somebody who they believed was part of their team and working with them to try to build a strong company. I've been asked many times over the last couple of months how someone does this, embezzles this amount of money, and Judge, it is always the same story. Someone who has sole access to the finances, gains everybody's trust, and is able to carry out this kind of a fraud. And at the root cause, Your Honor, of course, is greed. We would ask that you would accept the plea agreement, accept the sentence, order the restitution, and appreciate your time.
Mr. Kelly?
Your Honor, Mr. Hugh Johnson is a nice man. Never in a million years would he walk into a bank and rob it. In this case, he was given the keys to the vault. Unfortunately, he abused the trust that was given to him. It happened early on, and then there were obviously no controls, went on for 5 years. That's why the amount got to be so high. He's not a danger to society, Your Honor. He has no prior record. I'm asking Your Honor to consider work release for him as a matter of rehabilitation and as a matter of helping to begin paying back the restitution. That's all, Your Honor.
What's the state's position on work release?
All right, that was not something that was part of the plea, and quite frankly, it's not something that we had previously contemplated. We'll leave that in the judge's discretion. There is, as you know, a great deal of restitution here to be paid, but given the nature of the charges and the amount of time that he is going to serve pursuant to this plea, it's not something that we had agreed to beforehand.
All right, sir, please stand. Based upon consideration of the record, proper evidence or factual presentation offered, Your statements, statements of your counsel, statements of the district attorney, I find that there's a factual basis for the entry of the plea. You're satisfied with your attorney's legal services, and you're competent to stand trial. The plea is your informed choice and is made freely, voluntarily, and knowingly. Your plea is hereby accepted by the court and is ordered recorded. Give me just a moment, please. Give me a minute, in fact. Ms. Kelly, are you court appointed? I don't.
Yes, Your Honor.
All right.
$56 hours, Your Honor.
Mr. Johnson, you wish to be heard on the amount of time your attorney has in this, or the reasonableness of the fee associated with that time, which is $3,920?
No, I'm fine.
Well, your attorney said you're a nice guy, but really what you are is a crook. You're a thief. Whether you robbed the bank or whether you stole from people who put trust in you, in my book, stealing from people who trust you is a far greater crime than stealing from people you don't know. No one is ever punished for exercising their right to a jury trial, but people are rewarded for taking responsibility for their actions and not putting the state to their burden. I will say probably the first wise choice you made was accepting this plea, because based upon the factual presentation that I heard, I guarantee you, if you had been convicted of these after a jury trial, if you ever got out of prison, you would be in your 80s. Because there is absolutely no excuse for this. You weren't stealing to pay medical expenses for a sick relative. You didn't have an addiction other than your simple greed that you were trying to fulfill. You weren't a modern day Robin Hood, stealing from the rich and giving to the poor. You're just a thief who was greedy. You're not going to be eating at Ruth Chris for the next 140 months, however many days that works out to. I think it's about 420 days. You're going to be wondering what meat you are eating, because it's not going to be the steak that you dined on at Ruth Chris on someone else's dime. With the sentence that you're being imposed, I had you stand and I said, wait a minute. And the reason why I wanted you to stand there for that minute was because you're essentially going to serve 1 minute in jail for every 86 cents that you stole from this company. You know, the minimum time you're going to serve equates to about 6,782,400 minutes. So that minute you stood there is going to have to repeat itself that many times before you are given the privilege of wearing a suit like you're wearing today. And I will tell you, your request to come out here in a suit instead of the jail garb that most inmates wear speaks volumes to the court about the type of person you are. You're not going to have fine clothes to wear for the next 10 plus years of your life. You're going to be an inmate in prison garb. And then when you get out, you will not be able to earn the living that you had before, because you have burned a bridge that can never be rebuilt, and that's a bridge of trust for whoever you work for. And in accordance with your plea, charges in file 18 CRS 266 are consolidated into 18 CRS 265 for a sentence of a minimum of 70 months to a maximum of 96 months in the North Carolina Division of Adult Corrections. Counts in 18 CRS 268, 293, and 294 are consolidated into 18 CRS 267 for a minimum sentence of 90 to a maximum of 96, to a minimum sentence of 70 months to a maximum of 96 months. That sentence will run at the expiration of the sentence imposed in 18 CRS 265. You're ordered to pay restitution in the amount of $5,867,408 as set forth on the restitution worksheet in order. That, would you rather have that, do you want that docketed as a civil judgment?
We would, Your Honor.
All right, that will be docketed as a civil judgment. The cost of this action, well, I understand that you have a great amount of restitution to be paid. The cost of this action and attorney's fees in the amount of $3,920 will be taxed against you and docketed as a civil judgment as well. I will recommend work release, but only at the expiration of the service of the sentence imposed in 18 CRS 265. Court's going to also order a mental health assessment and require that you follow any recommended treatment. Is there anything further from the state?
No, Your Honor.
Anything further from the defense?
No, Your Honor.
All right, thank you very much.
You did the right thing, buddy.
Thank you, Your Honor. I believe that concludes business in here this morning.
Not right now. Okay.